Hello and welcome everyone at our Pride Business Forum webinar. Today's webinar will focus on new legislation on a partnership law that affects employers in a significant way. In April this year, President signed the new amendment to the Civil Code that introduced a new institute to the family law, which is a partnership between same-sex couples. In a nutshell, that means that same-sex couples can enter into a partnership that is governed by the almost by the same rules as marriage, except joint adoptions. As I mentioned at the beginning, this new law actually affects employers in a significant way. Many of you in the past changed your internal rules to treat LGBTIQ employees the same way as every other employees, and for example, to give them certain employee benefits, such as a day for registered partnerships and so on. And today we will look at how the new partnership law, let's call it like this way, will affect your actions from 1st of January 2025, when this law will enter into force. I'm very happy that I'm not the one who will be answering your questions, that this is our experts from A&O Shearman, Martin Bytrzanek and Viktor Wrablík. And before I give them a floor to start with a short presentation, I just would like to ask you to use this opportunity and to pick up their brains by asking your questions. You can ask the questions through the Q&A chat box that you see on the bottom layer of the Zoom window, or after the presentation, you can raise your hand. There is an icon of palm, so you can raise this palm and we will unmute you and you can actually ask the question verbally. So please don't forget to ask your questions, because otherwise I will be asking all the questions and it's going to be boring. So already during the presentation of Martin and Viktor, you can ask your questions, or I will be encouraging you to ask those questions during the Q&A session as well. I think that's it all for the introduction, and the floor is yours, Martin.
Thank you, Czesław. Good afternoon. Please let's introduce ourselves, mainly our law firm. Our law firm entered the Pride Business Forum a couple of years ago, and since then we have been assisting to Pride Business Forum and its members with update of their internal policies with respect to benefits given to employees. And we believe that it would be helpful for you to know some views, and these are mainly our views, because the law is not perfect in this way, on how to deal with the new partnership. My name is Martin, and I've been working for 10 years, and I've been helping to Pride Business Forum since our joining of Pride membership, Pride Business Forum. And my colleague Viktor, he is a member of our labor law team, and he's the best expert to talk about the impact of partnership on employees' benefits and on some issues connected with this new institute. So let's begin with some general introduction. I'm trying to, yeah, it's frozen. Okay. So the aim of this summary is not to provide you with an overview of all aspects of partnership. It's mainly focused on employment law. However, it would be helpful for you to provide you with some introduction. We are not going to evaluate this institute of partnership from the social perspective. I think that the discussion on this institute has been pretty tough, and I think SMEFAR has covered the social aspects and also legal aspects, but many social aspects of this institute in a very broad way. But we would like to provide you with with an opinion on legal issues connected with this institute. First of all, we need to say that the legislation adopted with respect to the partnership is not perfect. We believe that from legal perspective, like equal marriage would be better to introduce, as it would be very easy to understand what rights and obligations the married couple, irrespective of sex, have in a marriage. However, now the Institute of Partnership provide to partners the rights and obligations which are similar to obligation given to rights and obligations given to married couples. And according to this law, according to the amendments to the Civil Code, the rights and obligations should be of partners should be seen accordingly with respect as the rights and obligations given to married couples. From this very simple sentence introduced in the law, there are several aspects which are covered by this very simple sentence. And the main aspect is that the partners will have, in fact, the rights and obligation which are given to husband and wife. I think the main change is the change with respect to joint marital property, because this was something which was omitted in the registered partnership. It's also the automatic change of surname, or the partners can choose whether they would like to change the surname at the partnership ceremony, which should have the same formalities as a marriage. However, the name is the main difference of the ceremony. There's also possibility to adopt the child of a partner. This is something which was introduced in the legislation in a separate provision, because in general, like, the adoptions and all rights to children are given to married couples only. However, with one exception, that a partner can adopt a child of their partner. So this is the main change with respect to the parenthood, which will also have impact on employment benefits, as Victor will speak shortly, with respect to all the benefits and
leaves
given under employment law. And just for you to know how the current registered partnership will work in the future, the people who are currently in the registered partnership don't have to leave this partnership. This registered partnership will stay in place. However, from the new year, from January of 2025, it will not be possible to enter into registered partnership anymore, and the only way of same-sex institute will be a partnership. I think that's all from the beginning. Perhaps Victor will talk more about the Institute of Employment Law with respect to the parental leave, to maternity leave, and all the allowances given by the Czech law, and also about definition of children in same-sex couples. And I can add to his knowledge if necessary with respect to some institute of parent partnership.
Yeah. Thank you, Martin. So hi, in my part, I would like to talk about what will change actually in the employment situation, the usual employment situation, such as they are related to children. So when the parent wants to go on a special leave, such as maternity leave or parental leave, and the surrounding benefits, related state benefits. So in this slide, actually, I just want to discuss how it is now before the amendment in these situations. And just for some context, it is necessary to distinguish between the specific leaves, such as the maternity leave, parental leave, or paternity leave, which is regulated by the labor code, and are granted by the employers, and the particular benefits, such as the maternity pay, paternity pay, parental allowance, which are actually like regulated in different regulations in Social Security and state benefit regulations. And the reason I'm talking about this is this actually creates some inconsistencies, such as that, for example, a man cannot take a maternity leave under labor code and will take a parental leave instead, but he may be eligible to a maternity pay with respect to the benefits. So my table may, I hope it is okay, but it might seem inconsistent at times, but usually this should actually work in practice because, for example, while a man cannot take a maternity leave, he can go on a parental leave, which will be actually the same from practical perspective. Yeah, and so today, as Martin mentioned, it is not possible that a same-sex couple are both legally recognized parents to a child. And this is actually because of adoptions, because it's only possible, only married couples can adopt a child jointly. And even it's actually not possible even for a partner, for example, for a registered partner, or basically a partner in a same-sex relationship, to adopt a child of the other partner. This is actually not possible even for registered partners, and it's not possible also for companions, for people who are not in registered partnership. And that actually means that there can be only one person, one legally recognized parent to a child, and the other parent is unfortunately not legally recognized. It's called factual. It's actually just a factual parent with no legally recognized rights to the child. In the employment context, this actually means that all the benefits or the leaves that are granted by law with respect to children are granted only to one of the parents. So only only the legally recognized parent in the same-sex relationship can take a maternity leave or go on a parental leave and will be granted the maternity pay or parental allowance. And only one parent will be registered in the birth certificate. There is one exception, and
I will talk more about that.
Martin will talk about that, and the exception is when there is a foreign aspect, which is basically, I think, that when the child is adopted in a foreign country.
No, when it is adopted, but when there is a surrogate mother and the parenthood is established by foreign law. The joint adoption is still not recognized also under the case law, but I will talk more about that later.
Yeah. Okay. So, but I want to talk about only on the Czech specific situation in the Czech environment. So this creates a bit of an unequal situation actually for people who are in same-sex relationships and have children together, because the other parent from the couple, for example, when compared to standard relationships with two legally recognized parents, where for example the father will be entitled to paternity leave or also to paternity pay, and this is actually what we try to help the employers with when we are actually advising on regulation, on internal policies. And the employers, and a lot of them are part of Pride Business Forum. Actually, this is the only way how this can be equalized today, that the employers grant these leaves and also finance these leaves actually, because it's not provided by state or from the social security program. Actually,
I think the best example, just for your information, is, for example, when there is a paternity leave, and the father is not legally recognized as a father of a child, and we usually try to include in the internal policies benefit paid or paid by the relevant employer, that the father has 2 weeks of paternity leave and paid in the same way as a father of a child in heterosexual relationships. So that's why it's very important at the moment. It's very important to review the internal policies and to make the rights equal. But we will talk later about whether this will still be necessary with respect to the partnership. But I think this will be something which Victor will cover in this next slide.
Actually, the biggest gap that I see now is actually there are actually two. One is the other parent is not entitled to paternity benefits, and such as paternity leave and paternity pay, and the other gap is the one that is with respect to foreign parents actually, so which I think you will actually cover. So, and how should this change actually after the amendment? So the thing is that the amendment that was already approved does not actually change the labor law and social security regulations in any way. We have some unofficial information that there is some plan to also have corresponding changes in this regulation, but as far as I know, there is no official material out yet. But in this slide, I will try to offer our interpretation of how we think the relevant employment situation should be treated after the amendment. Because as Martin noted, actually, the amendment introduced an option for a partner to adopt a child of their partner, which basically means that after the amendment, there will be a possibility that there are 2 legally recognized parents to a child. So this actually changes the situation a lot for the better, I think, because this will actually mean that the other parent will be also legally recognized, and this means that both parents can go to in case of mothers, both parents can go to maternity leave, also to parental leave, and one parent from the couple will be entitled to maternity pay. The other will be entitled to paternity pay, and also one parent, the one that is caring for the child, will be entitled to parental allowance. Both parents, I understand, will be registered in the birth certificate, which is actually possible even today. But it's not factually possible to actually get there because it's not possible to adopt a child partner today in the same-sex couple.
Under Czech law.
Under Czech law. So this will actually help a lot, I think, because in the employment context, this will actually mean that both parents can have the corresponding leaves and the corresponding state benefits, actually. So I think this helps a lot. This is our interpretation of how this should be interpreted, the changes. But as I noted, it will be actually good to wait also on the amendment to the social security laws to help clarify this.
Yeah, I think this topic is very, very complex. We spent many hours with analysis of these benefits, and because it's very unclear from the perspective of law whether the interpretation of the private law saying that we should consider like the married couple, marriage, children in the same way as children in partnership as partners. But we have enough unofficial information, and we hope that this will be the case also in practice, that this will be interpreted in favor of partners.
Yeah.
Otherwise, I believe that they risk challenges at court, and mainly I think Constitutional Court may be confirming this if there is no law until that time.
Yeah, for now, I think it might be good to also have this covered in an internal policy, and maybe wait what will be actually the legislative amendments also in the labor laws and in the social security laws. But I think if someone would try to dispute this, saying that I have this right, I think it would be granted in most of the situations, which is a good thing, actually, I think. So yeah, so this is for the leaves. There are also some changes with respect to the care allowance, which is actually already rather inclusive, as it can be also taken in case of care for registered partners' family members, and also in case of care for a child living in the same household. So most of the use practical cases are already covered. But the amendment will also further extend this by legally recognizing also the other parent, so that situation where the child doesn't live in the same household, which may be marginal, but will be also covered. And also the in-laws, which I think is actually quite important, that the in-laws will be recognized as well. So for example, you might get a car allowance for caring about mother-in-law through a partner. Yeah. We believe that this is the correct interpretation, but it remains to be seen whether the Social Security authorities will also take the same approach. But I think it should be interpreted like this. Yeah. Because it's also the spirit of the amendment that the situation should be equalized.
Yeah, I think it's similar to like widowers and all the other family aspects which are covered by the amendment. It's a spirit of law to also cover this in-laws. And just for context, these are also the areas we usually cover in the internal policies, because we believe that at the moment, before the partnership is effective, we believe that this is the area which should be also covered by internal policies. If an employer decides to make the rights equal.
Yeah. So yeah, sorry. What about specific leave situations? So as you probably know, there are specific life events in relation to which the employer must grant the leave. So it's employees such as wedding or death of a close person or accompanying family members to a medical facility. The regulation today is not totally inclusive, as it does not cover some situations that same-sex couples may face, which a lot of employers, again, especially the members of the Pride Business Forum, try to equalize in their internal directives. And this is actually one of the things that we usually review as well. Yeah. The main gaps in this situation are caused by, from my point of view, by two things. That the factual parent is not recognized, and by the fact that the in-law family relationships were not recognized in the same-sex relationship. And as Martin noted, we hope that the amendment should help in this respect, that it should actually cover these gaps. As after the amendment, the factual parent gap can be cured by adoption, which was not possible until now, and the in-laws should be recognized, also in-laws that are get through a partnership. So, for example, today the leave is not granted, or the leave is granted only for a wedding and not to conclusion of a registered partnership, except for a state service, but not in the private sector. So in the future, after amendment, this should also cover conclusion of a partnership. So an employee should be granted a leave to attend his or her conclusion of partnership. Similarly to attendance of a wedding of a child, for example. So in the future, this should be interpreted that this should not cover only the wedding, but also conclusion of partnership. And again, what helps is that the adoption of the child will be possible also by the factual part, the other partner. So it will be possible to attend. The family will extend. What I mean is that it will be as there will be recognition of parent-child relationship. It will be finally possible to attend the wedding of the child, which was before only factual. Now it will be legally recognized.
I think it's worth to mention that this is also based on interpretation of the short sentence in the civil code, because the regulation, the government regulation governing these areas has not been updated yet. We have some information that is being prepared by no actual document has been published yet. So we are not sure whether this will be done by the end of this year, as it has not been drafted yet. And I believe at least first half of next year or the whole next year will need to be interpreted based on the general provision in the civil code saying that we should consider the partnership in the same way as a marriage.
Exactly. There's still a lot of legislation gaps actually that should be covered. The regulation that governs these types of leaves should be updated, and also the social security laws and also the labor law, I think, to remove all the interpretation gaps. But if we take the spirit of the amendment into account, this is how I think it should be interpreted. So to really equalize is the amendment should change also these things, because these small details also matter, I think.
I think it was not. I think that the process in the parliament was very messy because of, first of all, like if there was a proposal to have a marriage, like equal marriage, there would be really simple change in the law saying that marriage is between two people, and that's all. And all the other laws would be updated. Do not need to be updated in that case. However, now we have like a special category. They the parliament updated several laws, like law act on foreigners in the Czech Republic, act on registries. However, all relevant law has not been updated yet. So mainly the labor code and all the allowances like the social security law and so on. So I think that was not a good thing that it was not done at once, and this may be done in the future, maybe also in some very like a special procedure, so that they do it until the end of this year. But we don't think it's feasible.
So as for the other situation, some of those are already pretty inclusive, such as the birth of a child, when a leave is usually granted or must be granted when a partner is being transported to a medical facility and also wants to be present at birth of the child. This is already rather inclusive because it already actually covers companions. So marriage is not required in these types of leaves. But I think for future it should also cover parents and partners. So not really such any change here. As for the funerals, this is already rather inclusive as well, as I think it already covers also persons living in the same household. But what's a gap is that the in-laws are not recognized. So this should be also extended by the amendment, and after amendment, it should be also possible to attend funerals of partners and in-laws, And also what will help is the recognition of the legal relationship between the other parent that was not legal recognized until now. And the same applies also to accompanying the family members to medical facilities. Again, the same gap. And in the future, this should also cover partners and in-laws. And again, it will help that the parent-child relationship with the other parent will be recognized legally.
And I think another gap is partners not living in the same household for any reason. Like now it's not possible, for example, to attend funeral of a person who is not living in the same household. It is a part, like family partner, like this, from the social perspective, but does not live for a certain reason in the same household. It can also be the case. And now it should be the same as a marriage.
So I think that's all for me.
From the Czech law perspective, and I think it should be. We have also a couple of slides with respect to foreign institutes, because when we review the internal policies, we usually the areas we usually cover in many cases that they relate to foreign relationships, or the relationships which are established under foreign law, such as foreign adoptions, recognition of foreign parenthood, like the parenthood which was established under foreign law, and also recognition of marriage. And there are certain aspects which are also important for the labor law, from the labor law perspective, so that for example, a child is considered as a child of an employee or not, to consider whether the employee is entitled to certain allowances and leaves. As you can see, in this case, the partnership will not change much, and this is mainly because these foreign law aspects are currently governed by case law rather than by law. The Czech law is rather conservative in this way, and some of the areas were confirmed by the respective court as being the issue for the parliament, and some of them were recognized as a natural human rights. So to begin with is foreign marriage. There are many types of marriages which can be, or partnerships which can be established under foreign law. For example, the best example is the country which recognizes same-sex marriage, which has the same level of rights as the usual marriage. So the marriage is notwithstanding the sex of the married of the people in a marriage. It's, for example, the USA or the UK. The issue is when a citizen of the Czech Republic marries someone in the UK or in the USA, he's considered they are considered married as under the respective law, and the US law or UK law. However, when they come to the Czech Republic, they are either considered single. Or if they make an administrative step with respect to recognition of this foreign marriage or foreign partnership, they can ask the general registry in Brno, which is relevant for recognition of foreign marriages. They can recognize the marriage, the same-sex marriage, as a registered partnership, because under Czech law, and this was also confirmed by the Constitutional Court, under Czech law, the only institute which is relevant for same-sex relationships, for same-sex marriages or partnerships, is a registered partnership at the moment, and will be the partnership under Civil Code from January 2025. It means the Czech registry and Czech courts would recognize only the highest possible institute for same-sex couples, as is introduced in the Czech Republic. but they will not recognize the marriage with all the rights and obligations as granted to the respective couple under the relevant foreign law. Like the main argument of the Constitutional Court is that this is something which is rather like the social aspect, which is the Constitutional Court has confirmed that this is a matter of values, and the traditional family should be respected as a value of the Czech Republic. This is something what Constitutional Court said in several judgments. So at the moment, the married couples, same-sex marriages under foreign law will not be recognized as marriages. They will be recognized as a registered partnership or a partnership, but only with respect to the Czech citizens. At least one of the partners of the married couple, will need to be Czech citizens. So that the special registry would register this couple as a partners. The other institute is a joint adoption. This is even more sensitive area of recognition, because the rights and the child should be provided with the best rights possible. But the Constitutional Court said that joint adoption, notwithstanding whether it's established abroad, because the couple lives abroad for a long time, and they just want to have it recognized in Czech Republic, or they just circumvene the Czech law saying that the joint adoptions by partners is not possible. Notwithstanding this, whether this is the first or the second case, they would not recognize the joint adoptions in the Czech Republic because of the provision of the Act on private foreign law, saying that the adoption would be recognized only if it's in line with the Czech substantial law. It means the Czech law does not allow joint adoption of partners. Therefore, they will not recognize the foreign joint adoption as such in the Czech Republic. The other institute is a surrogate motherhood. And this is something which was challenged with the Constitutional Court, and this is the only case where the Constitutional Court, after several rounds of judgment which were against this recognition, they finally recognized in 2017. They recognized the parenthood with respect to the child, which was established in the USA. The case was that two parents, one of them being a Czech citizen, they live permanently in California. They have a child, and they wanted the child to be recognized as their child under Czech law, because when they travel to the Czech Republic, they want both of the parents want to be parent with respect to the child, so that when there is a kind of accident or something happens, they would like to have the same rights to the child, both of them, notwithstanding whether he's recognized as a father under Czech law or not. So this is the only case where the parenthood is established also under Czech law. Because of this case, also the Act on general registries was amended, so that now you can register like the parent 1, parent 2 in the birth certificate. It wasn't possible before this case law was issued. So, and I think this aspect of this recognition of parenthood is relevant for all the aspects Victor was talking about. It means which of the parents is entitled to leaves, and to social security allowances like parental allowance and maternity, paternity, paternal allowances. So as you can see, I think the table is very similar to what Victor was talking about, because the decisive in this case is whether the parenthood is recognized or not. For example, you have there is a joint adoption under foreign law. In the Czech Republic, only one of the parents can be recognized as a parent, and we come to the same conclusion as was in the case before the amendment. It means only one of them, and after 1st of January, under Czech law, the second parent can adopt the child can adopt the child of the partner who was recognized as a parent. So so I think this table is very, very similar. The decisive is always the status.
Yeah.
Do you have any comments on
exactly? So I think that the principle will be actually the same. Both parents can go on a leave, actually on a parental leave. There are some nuances until when, depending on when the adoption took place. So I think it's different when the child is under 3 years or under 7 years. But the principle is that both parents can take a leave, and basically the principles as to the allowances is that there will be only one allowance per child. And only you can only have one of the allowances, so meaning that one parent cannot have paternity pay as well as maternity pay. So usually I think what will happen in practice is that one of the parents will take maternity pay, and the other will take paternity pay, and then the one that will care for the child for the 3 years, for example, or will take the parental allowance.
Yeah.
And what's different is actually that both will be in the birth certificate. Yeah. Well, it's actually the same as after the amendment.
Yeah, I think we will have many questions. So we have 15 minutes left. I will just summarize in 1 minute what you can take from our presentation. The main takeaway is that the law is not perfect. There are many gaps caused by the case that by the reason that originally the proposal was to do very easy amendments saying the marriage is between two persons. Now there is a special category of parenthood of partnership which is not covered by all the laws. It's not yet, like the relevant laws are not amended yet. Therefore, there will be some kind of insecurity with respect to all the allowances and leaves and all the labor law issues until the relevant amendments are done. And therefore, we still recommend reviewing your internal policies if you would like to have the rights equal. You should still try to make this via update or amendment or your internal policies, because it's the most secure way for employer to secure these equal rights for same-sex couples. So Czesław, do we have any questions?
Yes. Thank you, Martin and Victor, for your short introduction. We have questions piling up already, and here I am to encourage you to either write more questions in the chat box or raise your palm, and we will unmute you. Before I start reading the questions, I will take the opportunity of the fact that one of our participants is Adela Horáková, who is a lawyer for a SMEFER initiative. And she will give us a little bit of her point of view or a SMEFER point of view on this bill and on upcoming changes in the bylaws that the ministries are preparing. So Adela, if you are unmuted, then maybe I'll ask you to say a few words, and then I will start with Q&A. Adela, the floor is yours.
Thank you, Czesław. And thank you to Martin and Victor on the excellent presentation and been very useful even for me to learn some of the labor regulations. I'm here to make a short comment from the perspective of the Equal Marriage Campaign on the new law. It's going to be a slightly different perspective than from, let's say, a commercial lawyer who is advising a client. There, the advice must be precise, somewhat, I would say, maybe conservative. Our role as activists and as people who are pushing for a change is sometimes to be maybe a little bit bolder and a little bit daring in our interpretation of the law in order to push the boundaries, in order to gain as much legal space for everybody in this country under the new law. I completely agree with Martin and Victor that the law is bad. So please do not shoot the messengers, do not shoot the lawyers. The law is extremely badly written. It was written very quickly in the parliament without any proper discussion. We, as the Equal Marriage Campaign, we did all we could to let the lawmakers know that this law, in our view, is badly written. Unfortunately, political deliberations were stronger than the legal ones. Therefore, we ended up with this law. So the problems with interpretation are not the fault of the lawyers who are trying to interpret it, they're a fault of the parliament. And that leads me to three things I wanted to say about the new law. The first two are the unclarities where I think we will try to push a little bit further than what we maybe heard. The one question is the recognition of joint adoption from abroad. It is true that the Czech law says that only such adoption that is allowed under Czech substantial law can be recognized from abroad. However, the actual effect of a second parent adoption or a successive adoption is having both parents recognized. So I feel there is a space, and again, this is unclear and unsure how the courts would interpret it. I think there is a space for us to claim that even joint adoptions under foreign law should be recognized in Czech Republic, because Czech Republic does or will, as of 1st of January, effectively recognize joint parenthood or parentage. And that is the factual result that is already approved by law, and therefore it makes no sense to impose restrictions on the recognition from abroad only because the couple over there went through a joint adoption and not a successive adoption. So that's one thing. The other one, and that might be a little bit maybe shocking to some, but I think there is even a space to argue that the joint adoption under the new partnership law is not expressly banned. It is so badly written that there is a space to argue that the same-sex couples may be able to jointly adopt, in addition having this new successive adoption. But I do recognize that's a very thin ice, that's a very niche interpretation. It's just a matter of how far are we willing to go with criticizing and interpreting this new law. But I completely agree that for the current practice and advising clients and for corporate purposes, we should go along with the notion that the joint adoptions are not permitted. But us as maybe lawyer activists in sort of criticizing this new law, I think there is a space to say that this is one of the points that is very unclear. Mm-hmm. And I see Martin and Victor nodding their heads, so I think they know.
I think it's about interpretation of Section 800. It was not ruled out that
exactly. I think if anyone who has a basic legal knowledge looks at the provision, and if you want to exclude something, you do it in a different way than they did it. But we ended up with this mess of a law, so there's not much we can do about it now.
Okay. Fear that the Section 100, I think it's 33, may also actually, maybe be against its interpretation. Because there was this judgment of the Constitutional Court a few years ago, and I think actually the reason why successive adoption, also not only in same-sex couples but also in heterosexual couples, was banned, it was because the section 833 of the Civil Code says something along the lines that after adoption, the child actually loses the family connections. And then in the second part of this paragraph is that that there is an exception for marriages, for married people, for married couples, but there's no exception for there's no exception for any other groups, which means that, for example, if I would adopt a child of someone other that is not of someone that I'm not married with, actually, and then the child would actually lose its legal relationship to its original parent, which I think was.
Yeah, I could ask you to, if we could go back to the questions of our people before we are losing them, and then maybe the space for legal interpretation of some legal provisions we can leave for afterwards. One thing is clear, there is a lot of work for lawyers from the 1st of January for those who want to actually challenge the law in the court. But Adela, if you finish, then I'll go back to the question.
I have one more. I have the third point to make, if I may.
Okay, and then I'll go back to the question.
And that actually, unlike what I have so far, might be interesting for the people online. So that's the thing about the interpretative provisions of the government. So should the corporations wait for the politicians to issue some new decrees that would interpret or clarify the unclarities of the law? I think at this point, we are not aware of the state preparing any such decrees. And I, from what I have heard, believe that the state takes the position of, well, anywhere where a marriage is mentioned, anywhere in the legal order, whether it is a public law or a private law provision, it should be interpreted in a way that that applies to partnership. The only decree that we know of that is currently being prepared is the one regarding the registry offices. So the process of entering into partnership and things related to it. So matriční vyhláška in Czech. That has gone to the legislative process today. I think it's there's a 10-day limit for the government to comment on it. And we'll see what comes out of the process. But there is the registrar decree, is the registry office decree, is the only decree that we know of that is going to be amended. So it is quite possible for the talent or the HR departments here that there will be no other interpretative decrees coming out of the government or out of the parliament.
Exactly. And that may be the answer to Alexander Vladimirov question, who says, does it mean that we should expect additional laws to be changed to clear all those gaps? The straightforward answer is not at the moment. We'll see what will happen later, if the government will act or not. But we can also expect that there will not be additional amendments to the bills. And we'll be left with our own interpretation, or the courts will help interpreting this this bill along the cases. I don't know if Victor and Martin, you want to add anything to this answer to Alexander's question.
Yeah, I think that's a good position, actually. We shouldn't rely that there will be something. I mean, we've got some unofficial information that something is being planned, but we shouldn't really rely on it.
I think discussing orally between the respective officers that this should be done, but nothing has been drafted yet as far as we know.
I think our advice would be to take a position, take an interpretation position, and then go with it. Yeah.
Exactly. Especially that, as we all saw, basically the election campaign started today before the election next year. So I don't think that there will be anything coming up soon in the government when it comes to the interpretation of the partnership law. The politicians are happy that they are done with it. Maria Orlova is asking, whether there is an update in case of two foreigners living in the Czech Republic, and if they want to, in case they want to enter the partnership, whether there is a change compared to the registered partnership. In terms of a registered partnership, one of them had to be of the Czech citizens. The question, citizenship has to have a Czech citizenship. The question is whether in terms of partnership, it's a different approach.
Yeah, maybe Adela can confirm, but I understand the law that this should be in this should be regulated in the same way as a marriage. So I understand the marriage can be also entered into by foreigners in the Czech Republic. So this should be possible.
Yes, if we take the approach that like everything is should be done the same as a marriage, then and if two foreigners can marry in the Czech Republic, then by this interpretation, that means that two same-sex people can partner. The two foreign same-sex people can partner in the Czech Republic. Donna is asking whether the terms maternity and paternity will continue after 1st of January 2025 when partnership is entering into force.
Well, I don't think anything is changed in the laws as of now. So yeah, actually, what will happen actually, or what we can do now is actually just to work with the term as they are written in the labor code. And as I said, actually, sometimes it is inconsistent that for example, a man can adopt a child and get maternity pay actually, but he cannot get a maternity leave because the labor code actually does not allow for it.
This would be up to decisional lawmakers whether they will update the terms. But they didn't before when there was like adoption by a man. It's still inconsistent also at the moment.
Yeah,
and
actually,
I don't think there will be a will to change something in the law in this respect, because it would cause additional problems with respect to interpretation of the other laws referring to maternity and paternity leave.
It's just the case it was built upon and built upon and then built upon, and now it would be very hard to I think to change it so this consistent. But it will be really good if that happened.
Okay, now I'm encouraging you all to ask more questions. As I mentioned, you can chat them, you can write them in the chat box or raise your hand and we will unmute you. I want to maybe clarify for everyone, and maybe it will be repetition, but it's good to clarify. The status we will be in after 1st of January. So we will have people who entered registered partnership in the past, and after 1st of January, they will want to change their status to the partnership, so they will become partners. We will have people, employees that entered the registered partnership in the past and will not want to change their status after 1st of January, and they can do it. They can stay in the registered partnership. And then we will have people who will decide not to enter any of those institutes. And the employers will need to react to all those situations, right? So I understand that you advise to every employer to actually change those rules in their internal rules. But how should the employer actually approach these different situations?
That's a very good question. Because actually, as you described it, it creates a bit of an inconsistent situation because you have all those groups of employees that you need to think about. So I think what can be done, and maybe Martin can amend it if I say something wrong, but to have it regulated in the internal policy actually. And just think about also all the cases that the law is forgetting about even today and even after the amendment.
I think the companies who had changed their internal policies before they shouldn't change it right now or omit some provisions we included there when we reviewed their policies, so that the registered partnerships are still covered. I think it's better to have more in the internal policies, and in once the partnership is relevant, and some of the employees they change the registered partnership to partnership, or there will be new with people in the partnership. The only difference will be, for example, that they will not have to pay it from their budget, from the company's budget, but they can cover it by from the allowances.
Yeah, exactly. Yeah.
So is it better to have more rights to employees than less?
Yeah, and it's good to have a clause in the internal policy that we only pay for this if the state is not already paying for this. Yes.
Sure, the money is the most important thing. But and maybe this is also answering Franciszek's question, who is asking whether we can, in bullet points, once again summarize what is changing for the employer in after 1st of January 2025. Because he had some difficulty in hearing the presentation, but I think if we'll take the approach, or if we'll take the interpretation that the partnership is ruled by the same rules as marriage, except joint adoptions, then for the employer, with this interpretation, it means that all the benefits that are for the people who are entering the marriage are the same, except the parental leave, if I understand correctly, right?
Like paternity, maternity, there is a because of the labor code and
Yes.
the term employee.
So sorry, I'm not sure if
that all the rights are the same as with straight couples.
Oh,
Only when there is like two fathers, they cannot have maternity leave under.
Sorry, now I follow. The rights are basically the same, and for example, it's a good example. For example, the father cannot go on a maternity leave, but that's just a technicality because he will go on a parental leave, so he will be at home, and he will get his leave. And as for the benefits, he will get the maternity pay from the Social Security. But the rights should be the same. Actually, there is no new institute that would grant some new rights to some specific rights for same-sex couples. This will actually go under the current provisions of labor code and all of the Social Security regulations, which grant benefits, for example, when the child is adopted, or and also when it's born. So
And we also need to take into account that the whole process of adoption will take some time, right? It's in case of straight couples, that once child is born, the father is automatically believed to be father, and he is entitled to those benefits. Whereas in case of same-sex couples, they need to request the adoption, and that will take some time. So those benefits cannot be automatically given to this couple, if I understand correctly.
Only after adoption.
Only after adoptions, exactly. Which will take some time.
Which will take some time. Yeah.
And therefore the internal benefits, internal policies are still important.
Exactly, especially in the case of this parenthood. Now, Franciszek is asking, would it mean change the regulations and obstacles to work, rights of specific employee groups in the meaning of Section 237 of the Labor Code? I hope, Victor, that you understand what is Section 237 of Labor Code.
So, sorry, I'll have to open the Labor Code.
Sure. Thanks God you have it there, because I have no idea. So let's give it a minute for Victor to look into the Labor Code, whether the new law will actually mean anything for the employer in 200 in this sense, 237 and following provisions, Victor, when you are looking at it.
Maybe this specific question we can respond to directly to do some.
It's just I don't have the Labor Code here with me, but I can look it up on the...
You cannot, because you stopped the presentation.
Yeah.
Okay, but František, we have your email address. So Victor and
I'll be happy to answer that. Yeah.
Martin will look into it and will answer that. Also next week, we have the same webinar, but in Czech. So we can maybe look into it and then have the answer ready also for the next week. But we will definitely send you email with the answer.
So is it 220? Sorry,
237 to 247 provisions of the Labor Code.
Thanks.
Now, there is also a question for the partnership, whether couple that is Czech and foreign live in different addresses if they want to. And I don't understand whether the question is whether the couple lives in different addresses and then enter to the partnership, or after they entering the partnership, whether they can live in different addresses. But I think it doesn't really matter.
I think it matters from the perspective of some of the leaves, because some of the leaves are tied with living in the same household at the moment.
Yeah.
And the question is whether after the partnership is in place, or whether after they enter into partnership, whether they don't have to live in the same household to have the rights granted.
Yeah, exactly. So it's relevant also for the specific leaves and also for the care allowance, actually, which also actually works with the people living in the same household.
Okay.
This will actually, after the amendment, this will change, because it will suffice if the person is a partner, so they don't have to live in the same household.
Yeah.
I will, for example, get the care allowance, or...
So they do not have to live in the same household. Once they are partners, they have the same rights.
So they can move after
okay, and before, so in order to enter the partnership, do they need to live in the same address? There is a specification of this question.
No. It's the same as with marriage. The couple, each of the couples doesn't have to live in the same household to get into marriage, to enter into marriage.
Thank you. Now Bara is thanking us for putting it together and saying that it is unnecessary mess and the politicians should have adopted marriage equality. Yes, we agree. We all agree. I think all of you did, as the companies were really big allies to the marriage equality campaign. Unfortunately, we have to deal practically with the mess that politicians left us with. And we will deal with it. And then let's hope that in very soon, politicians will realize that the only correct answer is the marriage equality. But till then, we need to deal with this mess in practical matters. Okay, more questions from you. We still have a couple of minutes to go. So if you have any questions, please don't hesitate to chat them in or to raise your palm and ask it with your voice. And meanwhile, we also ask you beforehand to maybe send us some questions that you have. And Jan Kotík did send us lots of questions, and those that are relevant for this topic around the employment and the partnership law. I maybe read some of them will be repetitive, but it's good to remind ourselves what will be the state after 1st of January 2025. So the question from Honza is, what about statutory leave days in case of in case of partnership? Are those who are entering the partnership automatically entitled to those leave days, such as days for wedding, time of funeral of the in-laws, and so on and so forth? We've said it already, but maybe Martin and Victor, you can repeat.
Yeah, we've talked about it actually on this, on this slide. So the answer is it depends on the case. In some cases, the partnership changes also or extends the application of the statutory leaves. So, for example, as you can see on the slide, we believe that, for example, conclusion of partnership should also get a statutory leave to the employee. So the employee can get a statutory leave to attend his or her own wedding. The same should apply, at least under our interpretation, to attendance of a wedding or conclusion of a partnership of a child. And this is also further extended by recognition of the successive adoptions. As for the funerals, we believe this should also cover funerals of partners and also of in-laws that the partner can get via his partner. So the mother of the partner. So for example, you can go on a funeral of a mother of a partner.
A mother-in-law.
Mother-in-law, yeah. Mother-in-law
Yeah.
gained through partnership.
But also this is like the best way would be to update this regulation of government, which governs these special leaves. But till then we have to interpret it in this broad way, as we just mentioned.
The best way would be to adopt marriage equality. Let's put it this way.
I
It
mean,
would actually
before
save
the-
them so much time, you know.
Yeah,
They wouldn't have
exactly.
to amend anything else. But hey, probably they like to have extra job. Okay. Last opportunity to ask questions to Martin and Victor. If you don't have any more questions, then, as I mentioned, next week we will repeat the session, this time in Czech. So you can maybe think of some questions and come back and ask them, or you can send it to us via email, and we will answer them next week. Also, if you have colleagues in your offices that are Czech speakers, and you think it would be beneficial for them to actually attend this session and to listen to these tips, how to prepare for the new partnership law at your company, then please let them know. No, it's next week. I believe it's on the 1st of October in the afternoon. So please let them know, and I hope that we will see them here. Okay. No question. So I would lead this to the end. Victor and Martin, thank you very much for your time, for your input, for your insight in this mess that we are facing from 1st of January. But this is not our fault. This is not the fault of activists. This is we can actually point whose fault it is this time, and it's politicians. Thank you very much for your time. Thank you for your insight. And for those of you who will see us next week, then it's great. And please do follow the website of Pride Business Forum, where we have a plan for the events till the end of the year, and join us on other events. Thank you very much, and have a lovely afternoon. Bye.
Bye.